Building on the legislation brought forward by the Building Safety Act 2022, the government has tabled a number of amendments to clarify and extend protections in some specific areas. This will further prevent freeholders and developers from escaping their liabilities to fund building remediation work. The Building Safety Act provided leaseholders with a range of protections to ensure that those responsible for building safety defects were made to carry out the works or to pay for them to be carried out. However, before and during the process of remediation, relevant steps may be required to keep the building and the residents safe. Relevant steps include such measures as providing waking watchers or additional measures such as fire sprinklers or simultaneous alarms. Unfortunately, there have been cases where the landlord has failed to put these in place or failed to pay for these relevant steps. This has caused the leaseholder to bear the financial burden or the necessity of the local authority for step-in. New Clause 30 places beyond doubt that the first-tier tribunal can order the costs of the relevant steps are met when making a remediation contribution order or a remediation order. New Clause 31, it is often the case that doing surveys or investigative works to discover the full extent of remediation required on a building takes time, money and effort, and those assessments can be invasive. New Clause 31 will place beyond doubt that the first-tier tribunal has the power to order that a respondent must arrange and pay for evaluation surveys or experts' reports to establish the full extent of a building's defects. Turning to New Clause 32, we know that landlords of buildings 11 metres and above are failing to provide, in some instances, alternative accommodation for leaseholders when they are decanted from their homes. This amendment will place beyond doubt that in addition to relevant steps and expert reports, the costs of alternative accommodation for leaseholders and other residents when they are decanted from their homes can be recovered through remediation contribution orders. Turning to New Clause 33, resident management companies and right to manage companies allow leaseholders to have more control over their buildings. However, at the current time, these management companies are unable to fund litigation against non-compliant landlords, as they are unable to recover the costs for doing so from leaseholders in their buildings. This amendment will allow such management companies, where the relevant lease allows, to raise funds for remediation contribution orders, making sure we continue to hold those responsible for life-threatening defects to account. Turning to New Clause 34, this repeals Section 125 of the Act. This was intended to allow for the recovery of remediation costs relating to residential buildings of 11 metres and above in an insolvency, and for these funds to be used to remediate the building. However, there is a conflict with insolvency law, and there is a risk that instead of being used for remediation, any sums recovered under this clause could be directed instead to pay down the debt. This problem cannot be easily remedied, so we are seeking to repeal the section at this time. New Clause 35, regulators need to be made aware if those responsible for relevant buildings, that is, responsible persons, become insolvent. This clause introduces a duty on insolvency practitioners to notify local fire and rescue authorities, local authorities, and, where necessary, the building safety regulator.
When it comes to building safety, we welcome the government's decision to use the opportunity presented by the bill to make a number of changes to the Building Safety Act 2022 to ensure it operates effectively. Although it must be said, Mr Deputy Speaker, the very fact that ministers are having to completely overhaul arrangements that came into force less than 2 years ago, for example, replacing the existing regime for dealing with insolvent developers and orphaned buildings by means of new clauses 34 and 35, vindicates entirely the concerns the opposition expressed back in 2022 about the way in which the then Building Safety Bill was overhauled at pace via hundreds of government amendments tabled in the other place that noble lords had relatively little time to consider carefully or properly scrutinise. I want to raise two specific issues of concern about the government amendments relating to building safety. The first concerns new clauses 30 and 31. These expand the concept of a relevant defect to which the leaseholder protections in the Building Safety Act apply, and that tribunals can order landlords to remediate. While we obviously take no issue with amendments designed to provide further clarification on how the Act operates, I'd be grateful if the Minister could tell us why the government believes these new clauses are even necessary, given that the President and Deputy President of the Upper Tribunal in the Olympic Village case have ruled that the Tribunal already has the power under the Act to order remedial works in respect of relevant defects, where the works are designed to reduce the risk posed by that defect, not necessarily eliminate it completely. In addition, I'd be grateful if he could tell us why, given the government are clearly willing to act retrospectively, the government will not go further and take steps to guarantee that leaseholder protections under Schedule 8 of the Act apply irrespective of when service charge demands were issued, and thereby prevent the Court of Appeal from potentially overturning the November 2023 ruling of the upper tribunal to that effect. The second issue, Mr Deputy Speaker, concerns new clause 32. This expands the categories of costs that leaseholders can seek to recover by means of remediation contribution orders, and will allow for the recovery of costs associated with professional expert services and any temporary accommodation. However, it will not allow leaseholders in buildings with fire safety defects to attempt to recover the significant costs associated with soaring buildings insurance premiums, which in many cases will continue to be levied after remediation works have completed. The government is rightly trying to improve the situation in respect of insurance charges by means of clauses 32 and 33 of the bill. Can the Minister tell us why the government will not allow such costs to be recovered via an RCO? Of course, Mr Deputy Speaker, not one of the 8 government amendments that relate to building safety resolve the underlying problems with the government's approach to it, namely the detrimental impact of the decision to exclude certain categories of leaseholders and buildings from the protections that have been afforded to others under that 2022 Act. As such, we've tabled new clauses 9 and 10 that would give the Secretary of State the power to bring non-qualifying leases and buildings, respectively, within the scope of the protections of the Act, and I commend them to the House.
Since 2002, we've also had the Grenfell Tower tragedy that has exposed the rotten culture of residential construction in this country. Members should wonder why it is that over 11,000 tower blocks in this country are reckoned to have fire safety defects, no fire stopping in building voids, a lack of compartmentation, combustible cladding, inadequate fire doors that leave residents at the mercy of landlords who literally go to the other side of the world to avoid having to pay for remediation. Residents are subject to unfair service charges and find themselves literally prisoners trapped in their own homes, unable to sell up and move on with their lives. This unjust system leeches off ordinary people and shames us, the only remaining country in the world where residential leasehold is the default tenure for apartment living. Your home should not be a source of misery to you and unjust enrichment to others. We're talking about the lives of 5 million people who need to be freed from their feudal burden. And this brings me to my new clause 19, which seeks to restore the intent of Section 20 Major Works regime in the 2002 Act to what it was prior to the Dejan ruling. The Minister was good enough in committee to confess that he was unaware of the ruling and said he would study it with his officials. And yesterday, I received a letter from the Minister on some of the points I raised at committee. He admitted that since Dejan, the vast majority of applications for dispensation are brought by the landlord, but goes on to say that, however, regardless of which party makes the application, the landlord will have to persuade the tribunal that dispensation should be granted, and it will be for the leaseholders to evidence that they have suffered prejudice. He said, I consider your concerns that leaseholders have to evidence prejudice, but only they are able to do so. Once that threshold has been met, the burden is on the landlord to rebut the impact the prejudice has had on leaseholders. He concludes, the consequence is that an application to the tribunal is not merely rubber stamping the landlord's request. I'm afraid I fundamentally disagree with him. Sue Bright, Professor of Land Law at Oxford University, has been conducting academic research into this area, and she argues as follows. The importance attached to the consultation requirements is evidenced by the fact that if the landlord fails to conduct the statutory consultation, it is prevented in the current form of the consultation provisions from recovering more than £250 from an individual tenant in relation to those works. Seemingly, this provides a very strong incentive to comply with the requirements, but the protection offered was seriously weakened by the Supreme Court decision in Dejan Investment Properties Limited v Benson. Lord Neuberger said the consultation requirements are means to an end rather than an end in themselves. He sees the provisions as playing a supporting role in achieving only the end goal of consumer protection secured by Section 19 of the Landlord and Tenant Act 1985, that is, protecting tenants from unreasonable service charges. An alternative vision, supported by the dissenting judgment of Lord Wilson, acknowledges that consultation is an important end in itself. This recognises that consultation has an inherent value. Further, it's in keeping both with the tenor of the new building safety regime that promotes fuller engagement with leaseholders and residents and the thrust of contemporary government policy towards providing consumer protection to leaseholders. Her findings are grim for supporters of leaseholders and the sense of fair play. She says in all of the fire safety cases reviewed for this article, dispensation was granted at least in part, and with a few exceptions. The overwhelming majority were granted unconditionally, even when the first-tier tribunal was critical of the way in which the applicant had managed things. I'd also like to thank Dr. Howard Soper, another academic who helped draft the amendment, who was appalled at the number of successful dispensations won by freeholders that he found in his study of first-tier tribunal decisions. I would urge the Minister to think again, as this cuts to one of the most fundamental injustices that we've seen in leasehold departments in recent years, those individuals who are trapped in buildings with fire safety defects.
And I want to mention yet again the continuing limbo for many residents of East Village in Stratford. Leaseholders in East Village have lived under serious financial threat for well over 4 years now. The remediation needed to make their homes safe is still being held up because this government's previous legislation left the issue open to litigation. So how can my constituents be reassured that this bill goes further? The Secretary of State himself committed to using his planning powers to call in proposals submitted by irresponsible developers. So I have to ask, will he make good on that promise and target those who are continually refusing to act on fire safety and leaving leaseholders on the hook?
I'm very grateful to the Minister for his assistance with the residents of Barrier Point in my constituency, and I think we now have a meeting in his office coming up next month. Last night I had a Zoom call with a regular Zoom call with leaseholders from Waterside Park in my constituency. Before Christmas we thought we had a clear way forward. Barrett's, the builders, have signed up. Aviva, the current freeholder, was happy. Last night on the Zoom call we learnt that the requirement of the building safety regulator to look at any proposals for a minimum 8-week period is going to very substantially delay the work which has been committed. And I do wonder whether the Minister can look at that and whether really it is necessary to insert another 8 weeks wait for residents who've been waiting so long for these problems to be resolved.
And finally, Mr Deputy Speaker, I come to new clause 15 tabled in my name. This amendment is to correct the unintended consequences of the Building Safety Act 2022. This is because the Act has interfered with the long-standing Section 24 regime, which was a vital right for leaseholders. The Building Safety Act introduced an accountable person mechanism that expressly banned Section 24 managers from being the accountable person. And consequently, specially trained, vetted and professional property managers willing to take on difficult sites have been barred from being the accountable person. This makes absolutely no sense and stripped leaseholders of an existing right. They surely cannot have been, this surely could not have been the intention that the government planned when it tabled the Building Safety Act, which was intended to provide leaseholders with additional statutory protections. There are so many leaseholders, not only in my constituency but across the country, who would benefit from applying for a Section 24 manager, but they cannot risk it if they are in blocks 18 metres or higher because of this issue with the Building Safety Act and the accountable person regime. It is imperative that our buildings are safe, that leaseholders are safe, and that the burden does not fall heavily upon these leaseholders. Mr Deputy Speaker, I won't push my amendments for a vote tonight, but I do hope the government will consider what I have spoken about today and will work with me to see what we can do to introduce them perhaps in the other place.
Another group of leaseholders who are really struggling are those living in King's Tower. It's a 12-storey building with a small amount of combustible installation on the spandrel panels on the outside of the building. It may need remedial work to remove and replace these. I think it's shocking that 7 years after Grenfell Tower, the huge company Barratt's and the property management company Estates Management Limited have still not carried out this remediation work. One of the leaseholders, Richard, emailed me today. He said back in 2009 the service charge was just £800 a year. This year he thinks he's going to have to pay £4,000. Richard and other leaseholders was first told of the potential issue in August 2020. He says that since then they've been unable to fulfil any form of normal life due to these additional fire safety issues and the costs. He says, I genuinely feel ill to think of what our service charge demand is going to be in March this year. So, as well as increases in insurance, Barratt's and E&M are blaming the increase on the costs needed to register the building under the new regulations of the Building Safety Act, which we introduced in 2022. I'd like to thank the Minister for his letter to me on this subject. But even though paragraph 9 of Section 8 was meant to protect leaseholders from the costs of legal and other professional services, it is clear that my constituents and many others feel that they are being gouged for excessive costs.
But in particular, on the concern he has about Dejan and building safety, I would be happy to continue the discussion to make sure that if there is an issue that we haven't worked through on this side, that we ensure that we understand that in more detail. The Honourable Gentleman from East Ham, we are looking at the point about the building safety regulator, and I'm happy to talk to him separately when I meet with the Right Honourable Gentleman